Hello, I am Rajat Solanki, Assistant Professor of Law at National Law University, Odisha, Cuttack. Today, I will be delivering lecture on classical positivism, where I will cover theories of Bentham, Austin, and Kelsen. Positivism covers 5 different meanings. First is laws are commands of human beings. Second, there is no necessary connection between law and morals or law as it is and ought to be. Thirdly, analysis of legal concepts is worth pursuing and distinct from historical, sociological, and from critical evaluation. Fourthly, legal decisions can be deduced by logical means from predetermined legal rules without reference to social aims, policies, and moral standards. And lastly, the moral judgments cannot be established or defended as statements of facts or by rational argument, evidence, or proof. Bentham distinguished expositorial jurisprudence, that is what the law is, from censorial jurisprudence, that is what the law ought to be. He regarded law as socially constituted fictitious entity. According to him, the good or evil of an action should be measured by the quantity of pain or pleasure resulting from it. The pleasure, according to him, included not only carnal pleasure but also more sublime form of satisfaction gained from intellectual and spiritual pursuits, noble deeds and sacrifice. According to his principle of utility, an action ought to be approved or disapproved according to its tendency to increase or diminish the happiness of the party whose interest is in the question. According to Bentham, a system of law that derives its rules exclusively from commands of a sovereign authority, when measured by the yardstick of public utility, is superior to the common law system, whereas the former produces clear, authoritative, and certain law. The latter generates cumbersome and illogical mass of precedents that serves the interest of lawyers but not of public. Bentham proposed that all laws should be codified. Further, according to him, law is an expression of will of a sovereign within a state. It requires a state that establishes sovereign authority. A society that lacks the superstructure of state and has no sovereign has no law in the sense of Bentham's definition of law. According to Bentham, any person or assemblage of persons to whose will a whole political community are supposed to be in a disposition to pay obedience, and that preference to any other person is a sovereign. Bentham suggested that sovereign power may be limited by constitutional rules that constrain the sovereign are merely rules of positive morality. Bentham struggled to explain the idea of legally limited sovereignty. According to Bentham, a covenant that seeks to bind his successor will be a recommendatory mandate that becomes covenantal only when adopted by the successor. Bentham recognized the absurdity of a person giving themselves a binding order. He said, it will be effective as law only if the sovereign is subject to outside force, such as a superior court with the power to invalidate laws in the event the sovereign is not sovereign. Bentham says, a sovereign's self-imposed limitations are enforced only by force of religious or moral sanctions. Further, the content of the law may be established by the sovereign by conception or adoption. According to him, conception is where the substance of the law is conceived by sovereign itself, as when the Queen in Parliament enacts a statute that lays down a new rule of conduct. Further, according to him, adoption is where the sovereign confers validity on a rule made by another person. This may happen in one of the two ways. Firstly, the sovereign may adopt laws already in existence and made by other persons. Bentham called this susception. Secondly, sovereigns may declare that they will adopt laws made in future by another person. This is pre-adoption. What we call delegated legislation today fall under this category. Not every expression of sovereign will generates law as it is commonly understood. Only the sovereign will becomes law when it takes the legislative forms. Administrative orders, military commands, judicial decisions are not laws according to Bentham. According to Bentham, a law is about conduct. Subjects of law are persons to whom the law is directed. A law may be directed at a single person commanding that to do or not to do a specified act. The objects of a law are the acts or forbearances that sovereign aims to secure by enacting the laws. Now, Austin. Austin dominated the British positivism till 1945 when the Bentham's work was first published. The work of Austin was largely derived from Bentham's. He applied analytical method. Law should be carefully studied and analyzed, and the principle underlying therein should be found out. And he confined his study only to the positive law, which he called just positivism. Austin is considered as the father of English jurisprudence. His lectures were published under the title The Province of Jurisprudence Determined. He defined a law as a rule laid down for guidance of an intelligent being by an intelligent being having power over him. Further, Austin considered that positive law to be the exclusive concern of jurisprudence, and the laws of God are subject of theology. He divided law into two different categories. Firstly, he called law properly so called. According to Austin, law properly so called are the laws based on authority. Second category of law according to Austin was law improperly so called. He called these laws based on opinion. Law improperly so called he further divided into two categories. Firstly, laws by metaphor or laws of science like gravitational law of gravitation, etc. And secondly, laws by analogy, that is moral rules, customary law and international law. These laws improperly so called was considered as positive morality by Austin. On the other hand, law properly so called was divided into two categories. Firstly, laws set by humans to humans, and secondly, laws set by God to his creatures as revealed in scriptures. Laws set by human beings has been again categorized by Austin into three different categories. Firstly, law set by sovereign and its official. Secondly, common law made by judges on the authority of the sovereign. And thirdly, law set by private person and other person in pursuance of legal rights. Austin categorized this under positive law. Austin recognized that customary law comprises rules that spontaneously adopted by a community whose members live by them. Hence, they remain positive morality until transformed into legal rules by legislation or judicial recognition. International law, as considered by Austin, is positive morality as it does not flow from the will of sovereign but consists of opinion and sentiments current among nations. Sometimes a custom is valued and useful in society that demands recognition as a positive law, and a custom that has outlived its social utility may be so entrenched that it can only be extinguished by positive law. Austin acknowledged that customary law may have some practical effects on positive sovereign law, but in legal universe it is not positive law according to Austin, because it does not flow from the will of a determinate human being. According to Austin, positive law comprises the commands of a political sovereign supported by sanctions on those who disobey. There are three key elements of this concept of law. Firstly, there is a political sovereign. Secondly, there is a command. And thirdly, there is a sanction. According to Austin, law is the command of a sovereign backed by sanction. A command, according to Austin, is not a request but imperative that creates a duty by presence of a sanction. Laws producing commands may be general in the sense that they constitute rules of conduct applying to classes of persons or events. The rules of criminal law are general commands, and they are impersonal and not directed to particular individuals. Commands are occasional and particulars. According to Austin, sovereign is an individual or group of individuals whose commands are getting habitual obedience from bulk of people. He attributed 5 essential attributes to sovereign. First is that the sovereign is a determinate human superior. Second is that the sovereign receives habitual obedience from bulk of people. And thirdly, the sovereign is not in habit of obedience to any other human superior. And fourthly, the sovereign's power cannot be legally limited. And lastly, sovereign is indivisible. Like we can give an example of Indian context, who is sovereign in India, whether it is the parliament which is sovereign, or it is the legislature which is sovereign, or executive which is sovereign, or judiciary which is sovereign. Putting the attributes of sovereign in these organs of government, it can be determined that there is no sovereign as such in India according to the attributes given by Austin, as neither there is a determinate human superior in case of legislature, executive or judiciary, neither there is habitual obedience to all of them, neither persons are habitually in obedience of the legislature, executive or judiciary, nor the legislature, executive or judiciary is in habitual obedience of any human superior, neither the power of legislature or executive or judiciary is legally limited, and also legislature, executive and judiciary are divided parts of the state. Austin distinguished positive law from positive morality. According to him, positive morality is an aspect of morality generally. It is moral to be kind to beings who are fellow, and to practice temperance, to give charity, and generally to be virtuous. There are moral values but not moral rules. In the legal system of Austin, positive morality is made up of moral rules that resemble positive law. Many rules of positive moralities are coexistence with the rules of positive law, like rules against murder, rape, robbery, theft, cheating are just few examples. If there is any contradiction between positive law and positive morality, according to Austin, the positive law prevails. Now I will be discussing the theory of Hans Kelsen. Hans Kelsen belongs to Vienna School of Thought, and he proposed a pure theory of law, that is, a theory free from social, historical, political and psychological factors. According to Kelsen, facts consist of things and events in the physical world. Facts are about what there is. When we wish to know what caused a fact, we look for another fact. A norm, according to Kelsen, is about ought to be done and not done, whereas facts exist in physical words, norms exist in word of ideas. Facts are caused by other facts, norms are imputed by other norms. Norms, according to Kelsen, is actually a hypothetical proposition. For example, if there is a theft, the person ought to be punished. Facts are caused by other facts, norms are imputed by other norms. Legal norms are coercive, whereas moral norms are not. A legal norm is valid if it is endowed by another norm. A norm that confers validity upon another norm owes its own validity to another norm, and so on. This regression cannot go on infinitely. Kelsen conceived the idea of a basic norm, which he called Grundnorm, a kind of first clause of a legal system beyond which we cannot speculate a legal sense. Norm is the meaning of an act by which certain behavior is commanded, permitted or authorized. A norm may take form of a rule or a specific command. Legal norms represent the meaning which we gave to a particular series of facts. The statement in a statute that something ought to be done is not a norm but a fact. The legal nature of this norm is evident only when all the interlocking provisions are taken into account. Kelsen mostly drew an important distinction between legal norm and the statement of rule of law. A legal norm is a command, hence it is neither true or false. Kelsen denied that there was a necessary connection between law and morality. A law that gives effect to a moral rule is law not because of its moral content, but because it is born of a definite procedure and a definite rule of law. A norm in the sense of an ought could be legal or moral. The rule against theft is moral as well as legal. Law is not only regulative system in society, moral norms play an important role in guiding behavior. There are two ways in which legal rules come about. Firstly, by custom, and secondly, by the will of law-making authority. According to Kelsen, the fundamental difference between law and morals is that law is a coercive order, that is, a normative order that attempts to bring about a certain behavior by attaching to opposite a socially organized coercive act, whereas morals is a social order without such sanctions. According to Kelsen, a norm need not supply a rule of conduct that can be known beforehand, a necessary condition for achieving the rule of law. However, not every expression of will directed to person is norm. Further, according to Kelsen, the Grundnorm must be efficacious, that is, people must believe in it, otherwise there will be a kind of revolution. In every legal system, Grundnorm of some kind there will be always, whether in the form of constitution or in the form of will of a dictator. Where there is a written constitution, the Grundnorm will be that the written constitution ought to be obeyed. Where there is no written constitution, one must look to social behavior for Grundnorm. Under international law, the Grundnorm is the principle of pacta servanda, that is, treaty obligation are binding on the parties. Grundnorm is the ultimate norm. It has no other norm to back its validity. However, all the other norms have another norm to be valid and effective. Grundnorm in Kelsen's legal sense is having validity without any backing of any other norm. Let's take an example of a pyramid. In case of pyramid, the Grundnorm will be at the topmost point or at the tip of the pyramid, whereas all the other norms will be below that, receiving the authority from another norm, and the ultimate authority can be traced back to the Grundnorm which is at the top. According to Kelsen, in the international sphere there are two possible Grundnorm. Firstly, the supremacy of each municipal system or supremacy of international law. Every national legal order can be ex hypothesis recognize any norm superior to its own Grundnorm. Further, Kelsen argued instead for a monist view of relationship between international law and municipal law and declared that Grundnorm of international system postulates the primacy of international laws. Nations in practice recognize equality of each other's legal orders, and doctrine of equality must mean that they recognize the existence of Grundnorm superior to the Grundnorm of their own particular legal orders. The first thing which his theory requires is the Grundnorm of international order. This is by no means clear that it may be principle of pacta sunt servanda or coercion of the state against the state ought to be exercised under the conditions and in the manner that conforms with the customs constituted by actual behavior of the state. Now, criticism of the theory of law proposed by Bentham, Austin and Kelsen. The theory of law proposed by Bentham was criticized on the ground that the definition is merely stipulative and the maximum happiness which Bentham is talking about, which can be provided by his law, is also provided by the English common law, which is actually the decisions of the court. His argument fails on this ground that common law has failed to fulfill the legitimate expectations of the people of England. Austin mainly focused on the command of sovereign and sanction, but his sovereign can not actually exist because in case of say India, there is no sovereign which can be equated with the sovereign of Austin. Or if you may take the example of USA, you cannot find a sovereign in United States also. So a sovereign which is presumed by Austin does not exist actually. And again, Austin was criticized on the ground that he called the international law as positive morality. However, the international law has gained much importance in the last few decades. Ultimately, Kelsen's theory is criticized as, according to Kelsen, a legal order is valid when it is effective. It does not matter whether it is an illegitimate rule brought about by unconstitutional means. Kelsen does not give any criterion by which minimum effectiveness of Grundnorm is to be measured. The effectiveness of Grundnorm depends upon sociological factors. Julius Stone has criticized Kelsen on the assertions that all the norms excepting the Grundnorm are pure. He asserted that other norms derive their authority from Grundnorm cannot remain pure when the Grundnorm itself is combination of various social and political factors. A summary of the lesson may be given in the following way. Positivism means the law as it is actually laid down, that is positum, has to be kept separate from the law that ought to be. According to Bentham, law is an assemblage of sign, declarative of volition, conceived or adopted by the sovereign in a state concerning the conduct to be observed in a certain case by a certain person or class of persons who in the case in question are supposed to be subject to his power. In case of Austin, Austin thought that law is only aggregate of individual laws. He defined law as the general command of sovereign backed by a sanction, whereas according to Kelsen, whose pure theory of law is based upon norms, law is primary norm which stipulates sanctions. A law, according to Kelsen, is de-psychologized command, a command which does not imply will in a psychological sense of the term. A rule expressing the fact that somebody ought to act in some way without implying that anybody really wants the person to act in that way. Now some concluding remarks on this lesson. Legal positivism is not only the school of thought within jurisprudence that seeks to separate the law as it is from the law as it ought to be. The ancient may have regarded the law as received from divine sources, but in the modern world, where most laws have known human author, people think of law as a product of designing human minds. British legal positivists regard the law as social fact, by which they mean that law is found in actual practices or the institution of society. Legal positivists have significant disagreements, but they have share in the common aim of helping people understand the law as it actually is. The analytical school is positive in its approach to the legal problems in the society. It concentrates on things as they are, not as they ought to be. The main concern of the positivist is law that is actually found, that is positum, and not the ideal law. The most important legal resources are legislation, judicial precedents, and customary law. This school, dominant in England, lays down the essential elements that go to make up the whole fabric of law. For example, state sovereignty and the administration of justice. The motto of this school is Ubi Civitas, Ibi Lex, that is, where there is a state, there will not be anarchy. The main proponent of this school are Bentham, Austin, Kelsen, Holland, and Salmon, etc. Thank you.